I think the next speaker we'll go to is Aliya. Aliya, are you okay to introduce yourself?
Yeah, absolutely. Thanks, Farheen. Thanks obviously to the Haldane Society for having us, and to LSU for organising this really, really important panel, and also to everyone who's given up their Saturday afternoon to be part of this discussion, which I think is incredibly important at this moment where the government is increasing its attacks on migrants and the rights that kind of protect them. I work at Migrants, Organise, which is a small charity based in West London, and predominantly on the Patients Not Passports campaign, which is about ending the hostile environment in the NHS. And I guess to reiterate, the hostile environment is the embedding of immigration enforcement across all sections of society, including into vital public services that people need to live and function and have a basic life, and sits alongside so many other racist immigration policies that are particularly cruel, including the detentionist state, things like no recourse to public funds, and much, much more. And I guess I wanted to talk a little bit today about the Patients Not Passports campaign and the kind of legal strategies and tactics that have been employed in the fight against the hostile environment in the NHS. I think and hope to get some discussion about the kind of merits and maybe the types of hindrances that some of these cause to a campaign against the hostile environment in the NHS. Really briefly, I'm just going to talk about what the hostile NHS looks like. There are sort of three main pillars of it. The first is the immigration health surcharge, which I'm not going to talk about, but is essentially a discriminatory double tax on migrants to use the NHS. The second and sort of main thing that we focus on in the Patients Not Passports campaign is charging migrants up to 150% of the cost of treatment for their NHS care, and including for the first time in the NHS's history since 2017, charging people up front. That is before they've been able to access care, and as a result, denying people care when they cannot afford the cost of that treatment. It embeds the charging system across the NHS, which we know is linked to the increasing privatisation of the NHS, and hope to sell all of it off one day. And it sort of embeds this culture shift away from healthcare as a right and towards healthcare being based on your contribution and your ability to pay. And the final sort of main pillar of the hostile environment in the NHS is, as happens across lots of other public sectors, is data sharing with the Home Office. So patient data is shared with the Home Office, who could then use that information for the purposes of immigration enforcement, including someone's home address, if they go to the hospital and say where they live. That can be used for the purposes of raids, and things like using the fact that someone has a debt to the NHS as a primary reason to reject somebody's visa application, which traps people in a cycle of irregularity where they can't, regularise their immigration status. And what we're seeing as a result of these policies is, as you would expect, people deterred from seeking the healthcare that they need, denied treatment on the basis of the documents that they had, which happened time and time again with the Windrush scandal, and happens all the time for people that we work with. People being questioned about their entitlement to care, and that affects not just migrants, but BME communities and all those who are racialised as migrants because of the racism of the policy, and people being forced to choose between their good health and their ability to afford food for their children, for themselves, or housing, and so on. It's having a really pervasive effect and really eroding sort of the principles of the NHS as this institution that is based on, healthcare as a universal right that we should all have, not about our ability to pay. The Patients Not Passports campaign exists sort of nationally, and it kind of aims to mobilise, in particular, healthcare workers and affected migrant communities to resist the policies. Through a kind of variety of different strategies and tactics, but one of the main ways is that we have different local groups that sort of organise around particular NHS trusts in an attempt to get those trusts to come out against the policies and say, hi, government, we really don't want to be doing this because of the harm that it's causing. And sort of in that process, amongst other organisations and others who are sort of working on the NHS charging policies, there are sort of different uses of the law. I think two that have sort of previously been used. The first is caseworkers in the migrant sector knowing the legislation back, inside out, back to front, and being able to use it to advocate for patients where trusts incorrectly charge people. The basic kind of advocacy, and we're seeing it happen all the time, that essentially the people tasked with administering these racist policies, this border enforcement, have not the foggiest clue about immigration law, which is quite frankly the most complicated section of law for anyone to get their head around, which judges don't even understand, yet alone an admin staff in a hospital somewhere who's trying to refuse treatment to somebody on the basis of their immigration status, which, as we know, changes often overnight, and as a result of circumstances beyond people's controls. And it's really important that sort of caseworkers are equipped with that knowledge of the law, and that this is something that we spread out, because what we're seeing often is that people don't know and are afraid to challenge when they get asked for a bill or asked to prove their entitlement to care. People think, oh, it's the NHS doing it, that I have to. And actually, most of the time, they're being billed incorrectly. Not that I think anyone is being billed correctly. So I think there's a question there about how do we increase people's capacity to challenge the law, to question it, and to question trust when they're getting charged or denied or refused healthcare. So the other kind of big way that other organisations who are working on NHS charging more broadly have used legal strategies to try and to undermine it is by using strategic litigation. So the use of judicial review. And essentially this has been, some major organisations have tried to take to judicial review the need to exempt certain categories of people from the NHS charging regulations on the basis, amongst other things, that it's discriminatory. So in particular, people have argued that, and in fact have tried to take to judicial review, the case that pregnant women shouldn't get charged for their NHS care because it's discriminatory. It's a burden that disproportionately falls upon women, and men, it's not something that men would ever have to pay. I think this kind of strategy raises a lot of questions about the kind of the use of JR, because what it essentially says is it legitimizes the policy as a whole. It doesn't seek to challenge the logic of NHS charging, but rather says there's this particular group of people who are particularly vulnerable, and we should exclude just them from charging. And if that were to succeed, which unfortunately actually, this case didn't proceed in court, what you're doing essentially is creating a smaller and smaller group of people that you're trying to argue shouldn't get charged for healthcare on the basis of essentially how sympathetic people are towards them. So you're going to end up with this very, very tiny pool of people, but it's incredibly difficult to try and say, actually, but they shouldn't be charged, when the whole premise of the NHS is that absolutely no one should be charged for their healthcare. And I think, so there's a kind of tension and a question here that arises around the need to balance challenges which ensure that people do actually have access to healthcare and to justice, whilst also not undermining the wider political points that we're trying to make, and also the principle of the policies. I guess for us in the Patients Not Passports campaign, the kind of main way that we're increasingly trying to use the law is in service of the movement that is sort of uniting to resist these policies. The government is increasingly fascistic, as lawyers I'm sure know about them describing activisty lawyers, defending human rights, how bloody dare you. But the government's not playing nice, and I think what we have to be clear about is that we can't either, that what this is going to take to overcome is mass resistance to these policies, and not kind of narrow legal means which often have implications in court, but often don't mean so much in wider circles, or can't be used by activists and by people trying to resist. So I think we were trying to think, what tools are at our disposal that could work not just to challenge in courts, but actually in practice. And I think one of the things that we've done is we've really looked at international movements in other countries where similar policies have been introduced to restrict access to care for migrants, and how other people have resisted. And there are movements in Spain, for example, Justicia y Sanidad Universal in Spain. They created a mass movement of healthcare workers who refused to implement the policy, and they had trade unions behind them, and they had some lawyers and legal workers behind them too. And we've kind kind of looked at this and we've said, well, what we actually need as in terms of the campaign is some kind of legal tool which can equip campaigners, and particularly healthcare workers in hospitals, with the ability to challenge the statutory obligation on the trust to implement these policies. And so what we're doing is we've found a QC who is hopefully going to write us some kind of guidance or an opinion, which we can then give to campaigners working in these local trusts, who can take those to trusts and say, as healthcare workers, this QC has said that there, you know, may be these areas of the law that the charging regulations actually falls foul of, and on that basis, because there are these discrepancies, you know, as doctors with a duty of care, with the, you know, the need to not discriminate against patients and so forth, that, you know, we can use these legal arguments to say to trust that we refuse to comply with the policy and we will no longer do it. And, you know, obviously that has to be, that kind of legal strategy has to be done in conjunction with a movement, with, you know, giving that document, whatever it is, to, for example, trade unions, who can disseminate it amongst their members, and their members can then use it to stand together and say, we refuse to implement. And this is, you know, this is something that we want to do across the UK, and in places where we have these groups organising and working. But I think it's going to require, you know, a real mass movement to do so. I think the other sort of final thing is that often legal workers are privy to a lot of information that campaigners don't have, particularly when it comes to something, you know, like the hostile environment and the impact. What governments and NHS trusts often say is that they don't have the evidence. They have no evidence of the harm. Firstly, that's because they're not bloody collecting it, quite frankly, but also because when, you know, a lot of the evidence is held by certain people who are dealing with cases all the time. And I think there is a responsibility on all of us to find a way to be able to share that kind of information as it's happening, so that campaigners can be using it and folding it into their work to be demonstrating the harm caused by policies, which helps push trust actors, whoever it is, to a position of, oh no, you know, we can't say we didn't know that there was a problem here. I was kind of going to finish there, but I think I wanted to respond to something Michael said earlier, which is about having to come out of our silos. And I think that's absolutely right. That often when it comes to the hostile environment, there, you know, people are working on different bits and pieces of it, whether that's around housing, whether that's around healthcare, whether that's around, you know, no recourse to public funds, whether that's around immigration detention. And I think fundamentally what we have to do is recognise that this is part of the same system and part of the same legacy of British colonialism, imperialism, and racism that continues to define what immigration policy is today. And so something we did at Migrants Organise is, in conversation with different migrant groups and community-led organisations that we work with, we created this document called the FIRM Charter, which is the Fair Immigration Reform Movement Charter. And I'll share a link to it in the chat, but it's essentially supposed to be a kind of framework that unifies many demands and is a banner under which many different people can be doing different areas of work, while saying, you know, whilst I'm working on healthcare and you're working on charging, we understand that we are part of the same movement, and where that movement comes from, and what it's fighting for, as opposed to just saying, you know, often what it is that we're against. But I'll drop some links in the chat as well, so that people can have a look at things. And thank you again for having us here.
Amazing. Thank you so much, Aliya. That was very helpful. I think it's particularly interesting what you mentioned about, I think you've mentioned this a few times in the conversations we've been having before this as well, the idea of like mass non-compliance and how lawyers are actually a very critical part of that. Like legal sector workers can be really important in not only increasing the accessibility of the kinds of legislation that underpin the things that they're opposing, but also in trying to equip them with the terminology, the ways of putting forward their arguments that will make sure that the people they're trying to oppose are convinced, basically. So yeah, that was really fascinating, and thank you for dropping those links in the chat.